Welcome back to the deep dive. Today we're really cutting through some of that administrative clutter. We want to deliver essential, specialized knowledge straight to you, the realtors working across Manatee, Sarasota, and the wider Tampa Bay regions. Okay, let's unpack this a bit. Our mission here is simple. Arm you with specific insights. Insights you need to be that absolute expert when your clients come asking about property taxes. That common high-stakes concern, right? I think my assessed value is just too high. Understanding this process, it's absolutely key for keeping those client relationships strong long after the closing papers are signed.
Precisely. We're taking a deep dive into a statutory right every single property owner in Florida has. It's the right to formally challenge their property assessment through something called the Value Adjustment Board, or VAAB. And look, this isn't just generic tax advice. We've really synthesized the critical path, the steps, and the local details for Manatee and Sarasota counties specifically.
That local focus makes this knowledge immediately actionable for you. You're positioned to offer indispensable guidance that could potentially save your clients thousands, really, over the years they own the property, all by just knowing the rules of engagement here. So let's start right at the beginning. We use the acronym VAB a lot, but what exactly is the Value Adjustment Board? What's its core function?
Yeah, good question. What's interesting is that the VAB is essentially a local tribunal. Think of it as quasi-judicial, established in every Florida county. It serves as the local check and balance on the property appraiser's office. And critically, it hears petitions about 4 distinct types of issues. First, and this is the most common one, disputes about the assessed value placed on the property, the dollar amount, basically. Second, it handles petitions when someone's been denied tax exemptions or classifications, like homestead, maybe, or agricultural status.
Okay, value and exemptions. Makes sense.
Third, they can address certain issues around property ownership. And finally, they deal with disputes related to a change of classification or how deferred taxes are applied.
That distinction between value and classification, that seems really important. We probably circle back to that later. But how is this actually set up locally for our listeners in Sarasota and Manatee?
Right, good to have context. So in Sarasota County, for instance, the VAB itself is made up of 2 county commission members, 1 school board member, and 2 citizen members. They appoint what are called special magistrates, usually qualified real estate attorneys or appraisers. Their specific job is to sit and hear the evidence from both sides, the property owner and the appraiser's office.
Okay, so appointed experts hear the cases initially. What about Manatee?
In Manatee County, the structure is similar in function. The VAB is required to meet at least twice a year, specifically to consider these petitions about value, exemptions, and classifications. The overall process is standardized across Florida, but the actual people involved are local.
Got it. Okay, let's shift gears a bit. Let's talk about the conversation you, the realtor, will likely have with your client. Knowing the mechanics is one thing, right? But knowing why a client might have a strong case. That's the real talking point. Beyond just saying, oh, the market's down, what are the concrete, maybe sometimes overlooked reasons a homeowner successfully challenges their assessment?
Well, if we connect this back, many successful petitions aren't just about overall market value. They often expose technical failures or outdated information. A really strong reason often cited is things like structural damage, maybe significant deferred maintenance, or especially here near the coast, damage from storms, damage that visibly reduces the property's value, but, the property appraiser's records just haven't caught up yet.
So just assuming the appraiser has perfect up-to-the-minute records,
Yeah.
that could be a costly mistake for the homeowner.
Absolutely. And another huge area for potential challenges involves technical errors, like misclassification. Imagine advising a client, maybe they own land that should be classified as agricultural, which has very favorable tax treatment, but it's mistakenly flagged as residential or even commercial.
Wow, yeah.
Correcting that simple classification error, it can lead to huge long-term savings, much more potentially than just arguing whether a house is worth $500,000 or $490,000.
That's a really powerful point. What about issues that pop up right after someone buys a place, or maybe after they do renovations?
Yeah, that often ties into inaccurate records about improvements or new construction. Sometimes the county records might show, say, an extra room or a new pool, maybe additional square footage that just doesn't exist. Or maybe the quality of the finish was much lower than the county estimated. If the property appraiser added sort of phantom value based on bad data, that's definitely grounds for a petition.
Okay.
And then, of course, there's the denial of standard benefits. Like if a homestead exemption was improperly denied, that often requires a VGA petition just to get the error fixed.
Makes sense. So several solid angles beyond just market value.
Exactly. Now, if we move to the actual process, the one thing you absolutely need to stress to clients is timing. Nothing matters more. If a client misses that filing deadline, the VAB petition must be dismissed, period. No exceptions, no second chances.
Wow. Okay, that sounds like the one mistake a client, especially one guided by a realtor, should absolutely never make. So let's nail down those deadlines. You mentioned they're tied to that trim notice mailer.
That's right. The VAB filing window is incredibly tight. It's directly linked to when that trim notice truth in Malige is mailed out. In Sarasota County, the formal deadline to file the petition is no later than 25 days after that mailing date. It's very specific.
25 days, that's not much time at all.
Not at all. Manatee County follows a similarly strict schedule, also tied to the trim notice mailing date. Now, if the dispute is about denial of exemptions or classifications, the window is usually 30 days after the notice of denial is issued, and that notice might actually come out before the trim notice.
Okay, so different potential triggers for the deadline clock.
Correct. And one more timing point. If the taxpayer decides to appeal a final VAB decision, they have to go to circuit court. That appeal must be filed within 60 days of the VAB decision. But here's the kicker clients often miss.
Uh-oh, what's the kicker?
The taxpayer must first pay the full portion of the taxes they do not dispute. If they don't pay that undisputed amount first, the court case might not even proceed.
That payment requirement. Wow, that's a huge technical detail to know. Okay, so that tight timeline means clients have to act fast.
To help our listeners keep their clients on track, can we maybe walk through the essential steps? Let's say starting with that first document they get.
Absolutely. We can break it down into about 6 key milestones. Makes it manageable.
Okay, step 1.
Step 1. Review the trim notice. As soon as it arrives, this is their official notification of the proposed taxes and assessed value. It's critical because it contains the petition deadline, the value they're proposing, and all the contact info needed for the VAB clerk.
Got it. Review trim immediately. Step 2. Step 2. Request an informal conference. This is a really highly recommended step, actually. The taxpayer should try to meet with someone from the property appraiser's office before filing the formal VAB petition. The goal is just to resolve it informally, if possible. This often clears up simple data errors. Maybe they missed some storm damage or mismeasured something without needing a whole formal hearing.
That makes perfect sense. Saves everyone time and money if it's a simple fix. But just to be crystal clear here, that informal conference does not push back the VAB petition deadline, does it?
That is absolutely correct. They are two separate processes running at the same time. You must file the formal VAB petition by the deadline, regardless of whether that informal meeting has happened or what the outcome was if that deadline is approaching.
Okay, crucial distinction. So, assuming the informal chat didn't solve it, we move into preparation. Step 3 is vital. Gather supporting evidence. What should a realtor be guiding their client to collect here? Is it just about printing comps, or does, say, the quality of an independent appraisal really matter?
The quality and relevance of the evidence is everything. This is where your market expertise as a realtor really shines. You need recent, verifiable, comparable sales comps. And not just from the same zip code. They need to be highly specific to the immediate neighborhood, especially in our market, right? With such variation between inland and waterfront properties.
Absolutely. Location, location, location matters even more for comps here.
Exactly. Evidence should also include things like clear photographs documenting any damage, maybe an independent appraisal the client paid for, or even invoices and receipts proving the cost of a renovation, especially if the appraiser seems to have overvalued that specific improvement.
Excellent point. The more objective and localized that data is, the stronger the case you're building.
Precisely. Okay, step 4. File your VAB petition. This involves using the standard Florida form. It's called DR 486, or sometimes the county has an online system you can use. The taxpayer has to pay a small filing fee. It's around $50 in Manatee County, for example. And this paperwork is officially submitted to the clerk of circuit court.
Okay, petition filed, fee paid. Now we move to the actual presentation, right? Step 5, participate in the public hearing. What should the client expect there? Is it like court?
It's less formal than court, but still structured. They should expect a brief, focused presentation, basically laying out the facts. The client, or maybe their representative, presents their evidence. The appraiser's office presents theirs. And remember those special magistrates we talked about? They review all this evidence. They listen. Then they make a recommendation based on who presented the better, more relevant market data. The VAB board then reviews that magistrate's recommendation and votes on the final decision.
Okay, so magistrate recommends, VAB decides. And finally, step 6. Review the decision and consider appeals. We already touched on the 60-day window to appeal to circuit court and that requirement to pay the undisputed tax portion first.
Correct. That covers the general path. Now, let's maybe bring this all back home. Let's talk specifics for Manatee and Sarasota realtors. This really raises an important question. How do we use the local setup, the local infrastructure, to maximize a client's chance of success?
Yeah, that's key. And I think we have to mention the technology advantage right away.
Hmm.
Sarasota County particularly allows for seamless electronic filing. That seems like a big deal. Clients can file the petition online, upload all those documents, photos, comps, appraisals, track the case status, pay the fee electronically. That simplifies the logistics so much compared to, physically trekking down to the clerk's office with paper copies.
It's a huge convenience, absolutely.
Hmm.
And going back to the evidence piece, given the incredible variation in our region, right? Barrier islands versus subdivisions east of I-75. The VAB and those special magistrates, they heavily scrutinize the local comparables provided. They have to be truly comparable. If you try to compare, say, a property near downtown Sarasota to one 20 miles east, the magistrate is very likely going to discount that evidence pretty much immediately. Specificity is just power here.
Right. Apples to apples, and make sure they're apples from the same small part of the orchard.
Exactly. And let's reemphasize the power of classification correction. We touched on it, but it bears repeating. If you, as the realtor, identify that a client's property is misclassified, maybe land with a valid agricultural use exemption is being taxed as residential, focusing on correcting that classification error. That often yields far greater and, importantly, permanent tax savings than just arguing for a slightly lower dollar value based on market fluctuations.
Permanent savings versus a one-time adjustment. That's a huge difference for the client's bottom line year after year.
It really is. And tying this back to the hearing itself, success ultimately depends on presenting relevant, clear, well-researched local market data directly to those appointed special magistrates. They are the initial, crucial decision makers. Their recommendation carries enormous weight with the actual VAB board. Persuade the magistrate, basically.
Okay, so what does this all mean then, if we boil it down? The major takeaway seems to be that, yes, challenging a property assessment is technical. It's governed by these non-negotiable deadlines.
Yeah.
But mastering this process, or at least knowing how to guide your client through it, makes you an invaluable resource. Success here can mean substantial compounded tax savings for your client over the entire time they own their home. Real money.
That's the bottom line. And the application is clear. Property owners cannot just assume the system will automatically fix an overvalued property or a classification error. It usually won't. Timely guidance is needed. Action needs to be taken early, ideally right when that TRI notice hits the mailbox. That allows time to prepare, file correctly, and present the strongest, most locally relevant case before those critical deadlines just fly past.
Absolutely. And as you guide your clients through these complexities, not just tax issues, but the whole transaction, you need trusted partners working behind the scenes with you. For truly seamless closings, comprehensive title services, reliable title resources, and just dedicated support for brokers and agents, you should definitely utilize Barnes Walker Title, Inc. They provide that trusted guidance for smooth transactions, covering everything from residential and commercial deals to even FSBO transactions across the region. And for those times when more complex legal solutions are needed, maybe intricate real estate law issues like contract reviews or property protection, strategic dispute resolution through litigation, or even essential estate planning and business law support, you can rely on the affiliated law firm. That's Barnes, Walker, Garret, Perron, Shea & Johnson, PLLC. They've been serving the Manatee and Sarasota region for over 30 years, with convenient offices across both counties ready to support you and your clients.
And maybe just one final thought to leave you with, something provocative perhaps. Given the potentially massive savings that correcting a simple property misclassification, like that ag versus residential example, can yield, consider how deeply understanding the nuances of local property classification and exemption rules, how that knowledge could become your biggest differentiator when advising clients in this really dynamic and growing market. That kind of specific knowledge, that's a serious competitive edge worth